Live from the Glasgow Electric Plant Board, Glasgow Wants to Know. With your host, Mr. Uhel Barrickman.
The Glasgow Electric Plant Board and WCLU welcomes you to another series of interviews with candidates for offices, the election to be held on November 2nd. Tonight we have as our guests the three candidates for district judge for the 43rd Judicial District, consisting of Barren and Metcalfe counties. The candidates as seated to my left are Barry Gilley from Edmonton, Cheryl Klapheke from Glasgow, and Barlow Ropp from Glasgow. We will begin tonight by asking Mr. Gilley to give a brief statement of his background, education, and occupation.
Thank you, Mr. Barrett. I'm Barry Gilley. I was born in Barren County at T.J. Sampson Hospital. I live at Wisdom, which is about halfway between here and Edmonton, about 2 miles across the county line. I was raised there at Wisdom. My father was Herbert G. Gilley, or some people know him as H.G. My mother was the former Drusilla Gray. They come from a long line of teachers. I've married to the former Nor Catherine Roberts. There are 3 children at home, Jay, Daniel, and Rachel, who are 13, 11, and 3. I graduated from Metcalfe County High in 1972, attended Western Kentucky University, where I graduated in 1975, cum laude in accounting and political science. I then attended Northern Kentucky University at the School of Law and graduated from there in 1978. At that time, I began my practice of law, opening an office in Edmonton, and have been practicing law from that time until now.
Mrs. Klapheke.
Thank you. My name is Cheryl Berry Klapheke. I grew up in Glasgow, Kentucky. I graduated from Glasgow High School in 1966. My parents are Harry and Mabel Berry. My dad has been a practicing attorney here in Glasgow for many years. I have 3 children. I'm a single mother of 3 children: Patrick, who is in college, Andy, who's in Glasgow High School, and Laura, who's in the middle school. I attended the University of Louisville and received a BA there in 1969, and I graduated from the University of Louisville School of Law in 1973. At that time, I moved back to Glasgow. I took the bar exam and passed it the following year, was admitted to the bar, and began practicing law at that time. I have been in Glasgow since 1974, and I am now a sole practitioner with my office on East Washington Street in Glasgow.
Mr. Ropp.
Thank you, Uhel. I'm Barlow Ropp. I was also born here in Barren County. I'm the son of Glenn E. Dick Ropp and Francis. My mother is deceased, Francis B. Ropp, Barlow Ropp. My father was for years the automobile Chevrolet dealer in Glasgow. I graduated from Glasgow High in 1957, attended Vanderbilt University and graduated there in 1961. I then spent 2 years as an airborne infantry officer in the United States Army, and after getting out of that, I went to University of Kentucky School of Law, graduated there with honors in 1966. I returned to Glasgow at that time and commenced practicing law with the firm of Redford and Redford, and then as time would have it, I ended up in the law firm that I'm in now, which is Richardson, Barrickman, Dickinson, and Ropp. I practiced law in Glasgow and Barren County and in other counties, and probably to some extent all over the state, in various litigation and in various trials in most state and federal courts in this state. I am a father of 2 children. Both of them are in college, or one of them's graduated, but both of them have attended college. My daughter is Catherine, and she's a center, and my son, Pal, is home looking for a job, and he's a graduate center also. My wife is Mary Ann Sams, a school teacher at South Green Elementary, and we live down on Hall Street.
Now, before we go any further into this, I think I should explain that, first of all, any election for judicial officers is a nonpartisan election. It is not an election of Democrats and Republicans or a contest between Democrats and Republicans. It's a nonpartisan election as provided for by the state constitution, which was changed by a recent judicial article that was enacted in 1976, I believe. The other thing I want to emphasize here tonight is that despite the fact that one of these candidates is my law partner and has been for several years, he doesn't know what my questions are going to be tonight. We have not discussed this, and he doesn't know the subject matter. And the questions are all mine, just as the questions for the two previous interview sessions that we've had on Monday night and Tuesday night. Now, since I've already indicated that, or stated that it is a nonpartisan election, there is known a judicial code that governs it, as well as the activities of judges in office. Since I started with you first, Mr. Gilley, have you read the canons of the judicial code?
Yes, I have. I have also been for the last year and a half or 2 years a domestic relations commissioner, have been subject to the code already, so I have read the judicial code.
Mrs. Klapheke?
Yes, sir.
Mr. Ropp?
Yes, sir, and like Mr. Gilley, I've been subject to it for 15 years, having been trial commissioner in the Barron District Court, and I'm very, very familiar with it.
Now, Mr. Gilley, would you tell the audience in general the terms of the judicial code, what it imposes on candidates and on judges?
Well, the judicial code is a code that has been passed by the Supreme Court. It is implemented to try to remove politics and improprieties from the office of district and circuit judge, as it should be. As far as it relates to candidates, the judicial code requires that we not take any positions on any public controversy or anything which might come before us or before any of the judicial bodies, and that we basically limit our campaigns to our qualifications as it relates to us and the candidates, other candidates. It does require that you avoid any appearance of impropriety, and there are many other specifics, too numerous to cover, but as far as it relates to the campaign, those I think are some of the main aspects of it.
Mrs. Klapheke, do you agree with what he said so far?
I do agree with what he said so far.
Now, can you add to it as to what will be some of your duties if you become the next district judge for the 43rd Judicial District?
Yes, sir. The duties of this office are numerous. They require the judges being able to write warrants, the judges hearing traffic cases, misdemeanors, felony arraignments, examining trials. It handles juvenile matters, probate matters, small claims, and small civil actions.
Mr. Ropp, have you got anything to add?
Well, excuse me, let me just fine-tune it a little bit. I agree with both Mr. Gilley and Mrs. Klapheke, but the judicial code is not intended to take the election out of politics. It's intended to take it out of partisan politics, which means that we are not supposed to identify ourselves with any political party. That doesn't mean we can't attend the rallies, and if you are asked, you can identify yourself by your party, but you're not supposed to make an effort to endear yourself to one party or the other, whether it is. The code also requires a certain conduct, even for people who are not elected judges, who are in the process of election. That's true, and it would require that you not get involved in any controversial issues. I agree with Mr. Gilley. It would require us not to answer any question you might ask us tonight, as to how we would decide a case, or what is our opinion on a certain matter that could possibly come before us. Other than that, I think we've all stated the issue, or answered your question adequately. Yes, sir.
What does it provide in the event you're elected and after you take office? Mr. Gilley.
Well, there are numerous provisions. Best I remember, there are, I was trying to remember how many there were, 7 or 9 canons, but it provides many things relating to your activities within the community. It again prohibits you from taking part in political activities for any candidate or any party. It prohibits you from, of course, practicing law in any way if you're a district judge. It does allow you to make speeches at conferences or at seminars in support of any perhaps passage of law or at a university or something of that nature, but it doesn't allow you to take the bandwagon for any person or any public issue that's to come up for election. It also requires, again, that you avoid any appearance of impropriety towards the litigants. It requires that if you have any financial interest in anything which might be tried in front of you or any of your immediate family, that you disqualify yourself. It further requires that you treat each and every individual with courtesy. That's part of the canons. It requires that you avoid, even beyond those rules, if anything you think might appear inappropriate to the judiciary as a whole, that you remove yourself and cease in a case in which it might appear improper.
Mrs. Klapheke, you care to add? Or?
Thank you. I believe Mr. Gilley covered that fairly well. There are a few additional qualifications or exceptions to that. One of those being, as Mr. Ropp said, that this is not a non-political office, it is a non-partisan office. There is allowance made for members of the judiciary to attend partisan political functions and to speak, as he said, if asked. And a presiding judge is presumed to be always campaigning, therefore is always allowed to attend these partisan events. In addition to that, the appearance, as Mr. Gilley pointed out, the appearance of any conflict or prejudicial attitude on the part of the judge would be cause for the judge to recuse him or herself automatically, and upon motion of either party would probably be the basis or be good cause for a judge to recuse.
Mr. Ropp?
You know, I'm not sure I understood your question. If they answered it, what you asked, I thought you were asking what's the difference in ethics, I mean the code between us now and after we get elected.
What I want to know now is what the code provides as far as conduct of judges are concerned after they elected and assume office.
Right. The only difference between what we've got to do now and what we've got to do then is we can't practice law. We're under the same constraints right now as far as this campaign is concerned and as far as ethics are concerned as we will be after we're elected.
But I'm driving at the conduct of the office after you're elected. Let's forget about the campaign now and talk about conduct in the office if you are the next district judge.
The ethical constraints, the judicial code constraints. The only thing would be is right now I can practice law and I can't do that after I'm elected. Otherwise it's the same. As a matter of fact, it's the same with some little exceptions for trial commissioners and for domestic relations commissioners. We can do certain things. We can practice criminal law in another district, or I can as trial commissioner. I can practice law without appearing in certain things, so forth. But it basically, that code binds candidates and campaign except for the practice of law.
Well, let's assume that you are elected and that you now have some matters pending in the district court. Then what happens, according to the judicial code?
According to the judicial code, I'd like to give them to you, but we may have a difficulty doing that because I could not hear any of my cases, nor could Mrs. Klapheke hear hers, or Mr. Gilley hear his. There would have to be a special judge come in till we get all that through the system. Yes, sir.
That's one of the things that the code governs after you become the judge.
That's right.
And there are many other things. For instance, what about the situation, and this could very well apply to you, of relatives practicing before you? And the code specifically has a provision for that. And I'm sure you understand what that is, Mrs. Klapheke, but I think the public is entitled to know these things. We're dealing in things right here and now that the public generally doesn't know, and I think is one of the things that causes the bar to be in disrepute. A lot of times they don't understand the judicial ethics code. You care to comment in the event you have a relative that should come before you with a matter if and when you become district judge?
Yes, Mr. Barrickman. If I have a relative come before me when I become district judge, there would be an automatic recusal. I cannot hear a case in which a relative of mine is a litigant or is representing one of the litigants. It's very simple, it's very cut and dried.
But there is an exception, is there not?
Well, there's an exception depending upon the degree of relationship.
But there's also an exception as to an agreement by all the parties.
Yes, there can be an agreement among all the parties to allow it to continue to be heard.
By you.
Yes.
But again, the decision basically goes back to whom as to whether or not there's an appearance of impropriety.
It goes back to the judge.
Now again, and I don't want to belabor the Code of Ethics all night, but there's some other things I think it might be well to cover for the public to know about. Let's assume that an individual, after you're elected and are sworn in, an individual comes to you in your office and wants to talk about a case that is pending before you. What happens, Mr. Gilley?
You have to refuse to discuss that with that individual. The canons require that we not have any ex parte matters discussed with a judge, and that's the same rules that has been in effect with me as Domestic Relations Commissioner. You must insist with no uncertain terms with those people that you cannot discuss those things except from the bench on the record with all parties that are concerned.
Now, you refuse to hear him. Have you got any other duty?
If they just come in and say, I want to talk to you about a case, and you say, no, I can't, and they let it go at that, I'm not sure that you do. But if they insist and try to ex parte you, I think that you have to report that to the authorities. I think there is a difference between coming in and someone saying, Judge, I want to discuss this case with you, and I say, I cannot discuss it, and they say, I'm sorry, I'm fine, and leave. That's one thing. But if they say, no, I want to discuss this with you, and I want you to hear this from me now, I think you have a duty to report that.
Suppose that the individual that comes to see you has a lawyer supposedly representing him, and that the other party that's involved, if it's an adverse situation, has a lawyer. What is your duty then? Well,
there are times, and as I know in domestic relations court, that an ex parte hearing is allowed. Now, that we have to get beyond those. There are times that we have had ex parte hearings on emergency basis where notice could not be had, but they're very specific by statute. I assume that you're talking about the things that do not relate to that statute.
Where there's an adversarial situation.
The canons require that a judge must report any unethical behavior or improper behavior that happens in front of him, and it is required by the judicial ethics.
And should you not also advise the attorneys that are involved in the case?
Oh, yes, sir. I assume the attorney should know that if they're practicing law, but yes, sir. You should advise the, are you talking about the other attorney?
If the attorney didn't know that
yes,
he came to
yes,
see you and so forth.
I think that should be the first duty.
Let's get on something else besides judicial ethics for the time being. We may come back to some of it a little later, but right now let's get on to something else. Of course, as one of you has already mentioned, and I've forgotten which one, the district judge presides over a small claims court. Mrs. Klapheke, expound a little bit on that. Its jurisdiction and what do we mean by small claims court?
Small claims court involves those cases which are brought before the judge, and essentially it has made the litigation of, not to be repetitive, but small claims, that is, those matters which do not exceed $2,500 in ultimate judgment, a potential judgment. The litigants can represent themselves. They state their case, so to speak, on a form that is presented to them by the district judge, by the district clerk. This form is then served as any other form would be served by the sheriff or through certified mail. The defendant is notified in that manner and told when to appear before the court. It's a matter of expeditiously handling and more easily handling and less expensively handling claims which do not amount to a great deal of money for the litigants and in which they might have difficulty finding an attorney to represent them. The parties appear before the judge makes a decision at that point, and the parties go home. It more or less cuts out the middleman, and the decision is rendered right there on the spot.
Mr. Ropp, you care to add to that?
No, sir.
As you well know, the present district judge televises through this station small claims court. If you become the next district judge, will you continue the practice of televising small claims court, or will you discontinue it?
I wouldn't say I'll discontinue, but I'll be very blunt with you. I have had a lot of people say that they are very nervous to go on television in their small claims cases. I'd want to take a long look at that. I think there's a certain educational benefit to small claims cases. Being seen, as you said a minute ago, it educates the public on what happens in their court system. And I think there is a benefit to it. But if it is, in fact, keeping people from going to that court and litigating their claims because they just can't stand the idea of being on TV, I think we need to make some adjustments. And without checking into it more, I wouldn't say I'm going to cut it out right like that. But I think, and I probably would never cut it all out. But there may be an opportunity to ask people would they rather not be on TV or something of that nature. I just have to take a look at it.
Mr. Gilley, what would be your position?
Well, mine's a lot like Mr. Ropp's. As I have gone through the counties, both Barren and Metcalfe, but we only hear this, of course, in the Barren County District Court because the Metcalfe County District Court has no such coverage. I have found a great dichotomy of people on that. Something I've not asked them about, but they have discussed with me. Some people think it's the grandest show they've ever seen, and they really enjoy it. They like hearing what's going on and knowing what's happening. And yet I run into other people, and some of the people who work within the system have told me that they say they wouldn't file a claim because they don't want to be on television. There has to be a happy medium somewhere where all segments of society, the public has a right to know what goes on up there, and we most definitely want to get out to the public what happens in court, because as you said a while ago, one of the great problems with the lawyers' opinions and the public view, I believe, is a lack of knowledge. And the more we can get out to the public what goes on in court, and the more they see what goes on, I believe they'll understand it better. But there has to be something, and I'm like Mr. Ropp, I don't know exactly what till we get into it and try to fine-tune it, but there has to be something for those people who do not want to be television celebrities, and we'll have to work on that.
Mrs. Klapheke, what's your position?
I agree. Since the time that cameras have been allowed in the courtroom, which, as I recall, has been within the last 10, maybe 15 years, but I think it's within the past 10 years, they have exposed to the public and made available to them knowledge that they would not otherwise have. Needless to say, we all will agree that L.A. Law and Perry Mason made for great entertainment, but they were not very realistic. However, what you see in small claims court is not only realistic, it may be your neighbor. I believe that this is vital to provide information to the public, but the primary concern must be that of the litigants who are there. There probably could be worked out something whereby those who did not wish to be on TV, whether the plaintiff or the defendant, could simply sign a paper and be scheduled at a time when the cameras would not be rolling. The others could then appear, and if they had no problem with being on TV, that is either party or however they wanted to conduct their case, they could be on TV and the public would still be served.
Under the system, the 43rd Judicial District is now entitled to 2 trial commissioners. Since you happen to be a trial commissioner, Mr. Ropp, would you explain to the public what a trial commissioner does and why you have trial commissioners, and then we'll get into some, after that, we'll get into some more questions about this.
All right, sir. Trial commissioner in the Barron District Court, or in the 43rd Judicial District, is probably most akin to what a lot of people remember as the old Judge Pro Tem. There are things a trial commissioner cannot do. He does not hold small claims. He or she would not hold small claims court, would not hold civil jury trials. There are certain restrictions you can't do in juvenile cases and so forth. But basically, can't marry people either. I used to get a lot of requests for that. Basically, the trial commissioner is an assistant type judge. We have one in Barron, and for 15 and a half years I did that on a regular basis, probably, I don't know, 10,000 cases or more. We have one in Metcalfe County. Now the law says that there is a trial commissioner, a county is entitled to a trial commissioner who shall be a lawyer if one is available in a county where the district judge does not reside. The question is, why do we have one in Barron? Well, Barron is a great big county as far as the business is concerned. Back in '78, I guess it was, the district judge convinced Chief Justice John Palmore that we needed one here because of the amount of business, and he permitted one. Like I say, he serves not when the judge is unavailable, and I said that once before, but he serves whenever it's necessary, whether it's 2 o'clock in the morning or Sunday afternoon or wherever it may be, with the restrictions that I told you about, that he or she could not do everything the district judge does. In some counties there are lay people, by the way, if there's not a lawyer available. Allen County used to have a lay person.
Now, as I understand the situation, the statute requires a trial commissioner in a county in which the district judge does not reside. But as Mr. Ropp has pointed out here, a second one is discretionary with the administrative office of the court, and that essentially means the Chief Justice of the Supreme Court. Have either of you checked to see whether Barron County will still be allotted an extra one for the next district judge? Have you made any made any check on that?
That wouldn't be necessary for me to check, Mr. Barrickman, because I reside in Metcalfe County, so Barron County would automatically have a trial commissioner. I reside across the line.
If you win, you're correct. Right. You're correct, but you won't have one in Metcalfe County. Unless
they do continue with the system that they have, and I have. But as far as Barron County, no, I have not checked, and I have not checked them.
And you have not, I take it you have not checked to see if you would have one in Metcalfe County?
No, I have not.
And I take it, since we're on the subject now, that if you're elected, you intend to continue residing in Metcalfe County?
Yes, sir. I continue to reside at Wisdom. It's my intention to stay there the rest of my life.
Now, another question which is important. Where is your main office going to be in the event you're the next district judge? In Edmonton or in Glasgow?
Mr. Barrickman, the district court in Barron and Metcalfe County, the work is so skewed towards Barron County that it's necessary that the district judge be here 4 days a week at least, as it has been so far. With Metcalfe County receiving the 1 day on Wednesday that they get now, and that's worked well. The Metcalfe County docket is not big enough to require me to move everything over there and stay over there. It can't work that way. We have to stay here, and if I'm elected, we have to stay here in Barron County and work this docket here, because that's where the number of cases are that we have to deal with.
Mrs. Klapheke, have you made any inquiries about it? Mr. Ropp?
Yes, sir, I have. The appointment, since I'm held it so long, the appointment is for Barron County. It is not for that judge. And the appointment is made, or the authorization is made, Mr. Barrickman, for that county, for the county of Barron, based on a certification of a need therefore. With all due respect to Metcalfe, and I agree with Mr. Gilley, there will not be a need in Metcalfe County because the load will not be great enough over there. So you will not, it's not a matter of, it's not a 43rd Judicial District trial commissioner, it is a Barron trial commissioner. And as a matter of fact, to be perfectly honest with you, back the first year that I was appointed, I served for nothing. I got no pay for it. Then they began to put some pay with it. But to be honest with you, the AOC doesn't particularly like this little trial commissioner sitting down there, because it's a special situation, because this is a great big district. As you've heard say, we're the 4th business in the state. And I agree with Barry that the bulk of the business is over here, and there have been occasions where Judge Dickinson was holding court in the courtroom and I was probating wills or doing some other things in his office. There's that much load. I don't believe there'll be that kind of load in Metcalfe, so you could get that trial commissioner. So we will lose a trial commissioner, I assume, if in the circumstances that you've had. But we would keep one if the district judge is over here, because it's assigned. Assuming the Chief Justice doesn't take it away from us. I mean, that's always possible.
Again, it's always possible that the
that's true.
AOC and the Chief Justice could take it away, as far as that's concerned.
That's true, yes, sir. They couldn't take away the one you talked about, and it's constitutional. It's not just a statute, it's kind of constitutional.
Well, there'd have to be one in the county in which the judge was not a resident.
That's right, and that's by constitution. Yes, sir.
That's why I was asking him whether he was going to remain in Metcalfe County, or
if I may respond a little bit.
Yes,
I think, another thing that could be considered in that would be the fact that as the Barron District Judge, if I'm elected, that I would have to be over here 4 days a week. That again would be left up to the AOC or the Chief Justice, which is outside of all our hands. But that's another consideration that they could take into consideration on that.
Now let's get down to some brass tacks again. In the event you are elected, have you already selected somebody to be your trial commissioner in Barron County?
No, I have not. I have not. I've decided not to make that a political decision. I don't think it should be. I think it should be a decision made on what's best for Barron County. And I have decided not even to consider one over another until this is over. If I am elected, then we'll try to make a decision on the trial commissioner on what's best for the system and what's best for Barron County.
Mrs. Klapheke, the same question.
I have essentially the same answer as it regards each county. I don't anticipate that the volume of cases going through the district court in either county would decrease. The population of Barron County certainly is increasing, and so long as we have the interstate going through here and the Cumberland Parkway going through the 2 counties, I don't anticipate the volume of district court cases decreasing in any way. Therefore, I would see a strong foundation for making a case to the Chief Justice or to the AOC to get an additional commissioner in this county, that is, as we have had in the past. Also, I don't believe it should be used as a political tool. It would be to the voters' best interest and to the citizens of these 2 counties' best interest to wait and see who is available, who is interested, who has the ability, who has the talent, and who has the time to give to it.
Mr. Ropp.
As far as Barron County is concerned, no. Nobody has been promised it by me over here. As far as Metcalfe County is concerned, I intend to keep Jimmy Coleman, Jimmy Kirk Coleman, and I'll tell you why. He's done it for the same length of time that I did it over here. He's got the experience, the qualifications. He's a fine lawyer. He's well respected in Metcalfe County, and that would be my choice, and there's nothing political about it. It's just that he is the obvious choice in Metcalfe County, it seems to me, to continue what he's doing.
If I may, Mr. Barrickman, I thought your question was only related to Barron County, and I too have told Mr. Coleman if we are allowed a commissioner that he can stay over in Metcalfe County, but I thought your question was only related to Barron County.
Well, in essence, as far as you were concerned, your thought was correct, because I wasn't thinking about you having one in Metcalfe County. So your conception was correct. But if you are allowed to, I understand. I think it's well that you have pointed that out. Now let's shift again. And we'll go with you first on this one, Mrs. Klapheke. What do you consider to be primary characteristics of a judge?
I believe that you should consider the character of the person and the personality of the individual. It should be someone, when you choose your judge, that person should be someone who is patient, who is willing to listen, who is tolerant, who can be firm, who can be understanding, who can discriminate fine points and technicalities, and yet see the forest for the trees. I believe the person should have a willingness to stay and wait and inquire into the situation fully. There shouldn't be rash decisions made. It requires an unending amount of patience, I'm sure, and it would also require an unending amount of firmness in that once the decision has been made and it's based on sound legal reasoning, it must be stuck with. And I believe that it's possible to render good decisions and be strong in those decisions and yet have the litigants come away with some understanding that they have received a fair shake.
Mr. Ropp.
Well, Ms. Klapheke said qualifications are certainly good, and nobody would argue with those. But the things I think that also are required are, if it's available, experience, training, on-the-job training particularly, and generally an experience in the broad area of practice of law. I don't think there's any experience much for on-the-job training, Mr. Barrickman, and I think that ought to be added as a prime qualification or characteristic for the job. Everywhere you look today, we talk about training, experience, continuing legal education, those kind of things. I think those are absolute qualifications for the job, and the more you've got of that, the better you are qualified, in my opinion. I do agree with what she said about the other things, though, obviously.
Mr. Gilley.
Thank you, Mr. Barrickman. To be qualified to be district judge or any judge is a combination of many qualities, some of which Ms. Klapheke touched on. I think judicial temperament is an extremely important aspect of any judge, because whatever decisions that a judge makes, his judicial temperament is going to make a lot of difference on how it's accepted by all parties. A diplomat can get things done where a dictator cannot at times, and I think that's the reason that judicial temperament is quite necessary.
Would you define judicial temperament?
To me, judicial temperament is the ability to referee a situation and to stay out of the emotions involved, to try to be a diplomat between the parties, because after all, a judge is a referee between the two parties. Judicial temperament is the ability to referee the situation without losing one's temper, without getting involved with personalities, and to try to maintain a proper and dignified and maybe somewhat of a laid-back atmosphere, and yet still in charge. It's a situation that one has to be in to understand exactly what that requires, and it entails a whole lot when you're dealing with advocates, usually lawyers on both sides usually, who are paid and do a good job of advocating their position. You have to sit in the middle as a referee and try to keep everything going according to the law, according to the rules of evidence, and yet maintain an air about you that brings forth the best in all and tries to keep it in more of an easygoing atmosphere. Now, to get back to what I was discussing about the qualifications, Mr. Ropp is also correct that experience is necessary. And it brought to mind one thing that I thought, as I said, a referee, you can't tell by looking at me, that I used to play a little basketball when I was in high school. I always remembered and found out that the referees that we had, we could tell quickly those who had played the game and those who had only read the book. Experience in trials is a necessary element for a judge. A judge cannot read the book and sit on the bench and be a judge. He has to have tried those cases. He has to have been out on the floor in front of the judge, arguing rules of evidence, arguing the law, so that he can understand the nuances and the movements, the strategies and procedures that a trial lawyer goes through. that makes for a good judge of any kind. So in our case, we have to have a judge, especially in district court, who has tried cases like DUIs, juvenile matters, small claims, incompetencies, all those things. If you're going to be experienced enough to know how to rule from the bench without having to stop and look them up, you have to have those experiences. And you have to have those experiences enough that they become more second nature to you. And I think that's a necessity for this job.
Mrs. Klapheke, you have anything to add?
I disagree to a certain extent. The position of an attorney, the trial attorney, is to be an advocate, not to be a determiner of the fact situation and to apply the law to it. It's to advocate one's client's position. Furthermore, if experience were the only basis for being qualified for this particular position, there would never be a reason for an election. A judge would determine who the next trial commissioner would be. That person would then become judge. He would, or she would, choose the next trial commissioner, who would then become the next judge. And so it would go, and rather than having a democracy, you would have a dynasty determined by those who first came into power, for lack of a better word. Certainly experience helps, but those who are in business also say that given the choice of experience or talent, talent is their first choice.
I don't think I heard any one of the three of you mention the word punctuality in what a judge does. Is that important or is it not important? Ms. Klapheke, you had the floor.
If one is going to continue keeping a docket in the order in which it's presently kept, and if one is going to continue having a flow of volume of cases go through a court system as goes through here, punctuality is vital. One must begin on time. One must be capable of ruling in such a firm manner and controlling a situation so that things do end within a reasonable amount of time while still allowing all parties to have their say. Additionally, deadlines must be met. If the deadline is next Friday, that doesn't mean that next Friday you say, uh-oh, we'll wait till the next Friday. Let's see if that won't work out. That's not to say there can be no allowance for such things. It's just that that must not be the habit. Punctuality is vital for the successful administration of the court system.
Mr. Ropp.
Yes. The answer is yes. Punctuality.
Punctuality is not only necessary, it's extremely vital. Whoever is going to be district judge, and I hope it is me, must appear in court on time, should be there ahead of time. A lot of times there are things that can be worked out prior to actually the opening of court. Both parties and litigants are there. He must be willing to get there early and stay late, put in the hours and the work and the hard work that it takes to get the job done. This is not an easy job. This is a job that requires hard work, and it requires someone who's willing to put forth hard work because of the volume of the cases.
This is a quickie for yes or no only, because then I want to wind this up with giving each one of you 5 minutes to tell the audience why you should be the next district judge for Barren and Metcalfe counties. But first, last question. Some district courts have night sessions under certain circumstances. Do you see any need for a night session or a change in time, court times, in the present system? I'll start with you, Mr. Ropp.
I spend a lot of time working at night. Is that why you asked me that question? Yes, Mr. Barrickman, I have discussed that with some folks who are helping me in the election, some lawyers, and I'm going to very seriously consider a night session. And I'll tell you, if I may be permitted, let me tell you why. Because having held court in that court for 15 years, I know that there is a strain on some people who need to be at the factory, who need to be doing their child care, who need to be at the doctor's office and so forth. It is an excellent idea, but before our wonderful clerk has a stroke out there somewhere, let me tell you, Nancy, I'm going to talk to you about that first, and I'm going to talk to Lou, and I'm going to talk to the people in the clerk's office. We're not going to ram it down anybody's throat, but I do think, Will, that it is an excellent suggestion, and I have thought that for 4 or 5 years, that could be done. It's not going to be held at 10 o'clock at night, but it certainly could be held at a time that you wouldn't have any, you'd have to not have any prisoners, or you wouldn't have to, but you wouldn't have any prisoners, and you wouldn't have any, probably anything that would require probably a disturbance, or you might be concerned about security over. But you could certainly have the routine traffic cases, you could have the routine no insurance cases, you could have the cold check cases, and those kind of things where you could have just the personnel you needed and have people come through there. Yes, sir, I think excellent idea. If the clerk can work it out with us.
Yes or no?
Yes.
Mr. Gilley?
Well, I think we'll have to deal with more people than just myself to deal with that. We have, as Mr. Ropp said, you have to have a clerk, you have to have a bailiff. It's an idea worth exploring, but there are a lot of other people to consider than just myself before I make that kind of decision for other people.
So your answer is you don't know as of this time?
I don't know at this time because I don't think it would be incumbent upon me to require other people to hire extra staff or whatever without going over that with them. And I think that's something that we'd have to deal with after the election, and to deal with those people and see what they wanted to do and what they thought about it.
Now, Mr. Ropp, you have 5 minutes to tell the audience why you should be the next district judge.
Thank you, and I thank the plant board and the citizens of Glasgow for listening to us. I'm not going to take 5 minutes to tell you why I'll be the next district judge. I'm going to tell you that I feel as I ought to be the next district judge based on my experience, my talent, my ability to be patient, my knowledge of the law, my long-time practice of law, and I'm trying to go over all the points that my 2 opponents said you needed for a district judge. And I believe in my heart that I have those qualities. And plus the fact I have got a quality that neither of my opponents have, and that is actual, hands-on, in the court experience, in the very court where I want to be judge. You can't get that, and talent is no substitute for it. It's like we're talking about night court. In my opinion, you wouldn't need a bailiff in night court because you wouldn't have any need for a bailiff in night court. I have every reason to believe that Mrs. Watts would accommodate you in that. But those are the things that I'm aware of because I've been there for 15 years. In today's world, we talk constantly about experienced workers, trained workers, people who can go to work now. I can do that. I have tried cases, everything I think that Mr. Gilley mentioned over there, and probably when he was still in high school. But I'm not trying to be flippant about it. I have tried cases of every kind, including $15 fender benders and so forth. I have a broad range of experience in law practice, have a broad range of experience in dealing with all kinds of lawyers. The judge is not a referee. He is an integral part, and cases in this Commonwealth have so stated. He is an integral part of the trial. And the courts the Supreme Court of the state has said on many occasions, the judge does not become a referee. He must make rulings that have an orderly type court. It's not just a matter of saying, I'm going to referee, keep you people from killing each other. The judge needs to be someone who has got the temperament, and I would invite anybody who doesn't know me, and I've been around here a long time, but anybody who doesn't know me, go ask somebody in the courthouse about my performance on the bench. Go ask somebody, any law enforcement officer that you may know. Now be fair and don't ask them who they're going to vote for. Just go ask them about Barlow Ropp's performance. Go ask them about me as a human being. Go ask them about me, particularly law enforcement officers, when I've gotten up at 2 o'clock in the morning to go sign a domestic violence order for some lady who's being whipped up on by her husband, or because her kids are locked in the house. That's the kind of thing that comes from experience and knowing how to do it, and having done it, I know the patience that's required. I know the temperaments that's required. See what they tell you about Barlow Ropp's temperament. See what they tell you about Barlow Ropp's patience, his ability, and how he's done it in the past. Those are the reasons, Joel, that I feel like I'm the best qualified to be district judge. I'm not running this race on the basis of who my parents are, or whether or not I've got kids, or where I live, or anything. I'm running this campaign based on my experience. I've been at it for almost 16 years. I planned it to run if the opportunity ever came available, and I have guided my career in that way, hoping that I would be able to be district judge someday if it is the pleasure of the people. Thank you very much.
Mrs. Klapheke.
Thank you, Mr. Barrickman. To the citizens of this community who are interested enough in this position to be listening tonight or to be watching on TV, thank you. In 1974, I began practicing law in Glasgow, Kentucky. At that time, I was the first woman to ever practice here. I wanted to do other things as well, and when I found that this position would be available, I decided that this was one that I would like to have because I felt that I had a great deal to contribute, not just for myself and for my family, but to the community and to both of these counties as well. I have spent most of my life developing a philosophy of life which I have been willing to share with all of you. Those of you who have met me, and most of you in one of these two or in both of these counties, have had the opportunity to talk to me over the past 2 months or at some time during the past 20 years since I've been back here. And in the course of those conversations, I have made my beliefs known to you. I have made, I hope, my talents available to you, and I hope that you have learned that you can trust me and that I have the characteristics that you would like to find in a judge. I have a knowledge of the law. I have experience as a hearing officer for the Workers' Compensation Board. That didn't require me just to go look up the law and see what it was. It also required ruling on evidence at times. It also required allowing litigants who were generally those who had been injured on the job and who were in difficult situations at best, making them feel comfortable and knowing that they could have the opportunity to present their cases in a setting that was adaptable to them and available to them and for their use. That experience, along with other experiences that I have, which I, for lack of a better word, have called life experiences, have trained me, I think, and given me the judicial temperament that's necessary. My background and my training in the law have given me the knowledge of the law, which, combined with the training that's available through the AOC, would make me available also and ready to go on the job the first day that it's ready and available for us to take office. Thank you.
Mr. Gilley.
Thank you, Mr. Barrickman. I could agree with a lot of things that both of my opponents have said. The main thing that is an issue in this race, I believe, is the experience necessary to be the district judge of Barren and Metcalfe County. Now, one of the things that I have that I think neither of the opponents, my opponents have, is that I have tried numerous cases in Barren District Court, Metcalfe District Court, involving the kinds of cases that I'm going to have to be ruling over. I've tried many DUIs. I have tried juvenile cases from beginning to end. Several cases that are extremely intricate and important. I have had a juvenile case relating to a juvenile murder. Those are important things for the district judge because the juvenile case is the most complicated of all of the cases that you will have to see. I'm familiar with those. I have tried all of the kinds of assaults, all of the criminal cases that you will see. Neither of my opponents have much experience in that, and as a matter of fact, as trial commissioner, Mr. Ropp was prohibited by law from trying those cases in district court. So he could not be an advocate in the court in which he was trial commissioner. In addition to all that, in addition to being familiar with those rulings, in addition to being familiar on a day-to-day basis with those laws, I have also been for the past year and a half, maybe close to 2 years, the Domestic Relations Commissioner. Well, you might say, what's the difference? Both are commissioners. It's a big difference. A trial commissioner accepts pleas in district court for the judge, can hear small, uncontroverted things dealing with wills, probates, and matters. But he does not, on a day-to-day basis, preside over trials involving litigants, parties, attorneys. A Domestic Relations Commissioner, on the other hand, is not a fill-in. He is the judicial officer who is required on a regular basis to hold court in what some like to call divorce court, a very important and a very emotionally charged court. He actually sits on the bench during a trial, or she, rules on evidence. You have lawyers on both sides, you have parties on both sides. And he must or she must, after it is over, make a decision of recommended to the circuit judge. Now, that recommendation goes up to the circuit judge as like an appeal. They can file exceptions like they can to any other court. But that gives me the hands-on experience in a courtroom situation with attorneys on both sides, ruling on evidence from the bench. You don't have time to look those up. Those you must know. It has also given me experience on how to handle trials. And like my opponents, I would invite you to ask those people who have been in front of me, ask those attorneys who have argued cases in front of me to see what kind of judge I have made so far. Because I have experiences both ways, both in front of the bench, with all of the trials that we're going to be involved with in district court. I think I have the most experience and the best temperament to be the district judge in Barren and Metcalfe County. Thank you.
Well, we still have a few more minutes. I thought each one of you were going to talk a little bit longer. Yes, Mr. Ropp?
Mr. Gilley must not have ever been in district court. I don't want to get in an argument here, but the Domestic Relations Commissioner makes no decisions. He simply recommends. I am not prohibited from practicing juvenile law in district court. I am prohibited from practicing criminal law in district court. But, I mean, I think we ought to have the record straight here. I hold contested hearings and have. I'm not a fill-in. I hold court when it's needed, and the decisions I make are binding record decisions. This Domestic Relations Commissioner makes no decisions at all. They're not binding on anybody till the circuit judge says he accepts them. And, you know, Mr. Gilley is a good Domestic Relations Commissioner. I'll take up for him. And domestic relations are very important. But we need to be clear about what people do in these various commissioner jobs.
Certainly, I may respond to one thing. I took the fill-in. I thought, Barlow, I'm sorry if from you said you filled in for Judge Dickinson.
No, I definitely said that, Barry. I said I would do it when he was unavailable some.
Mrs. Klapheke, you got some last words of wisdom here?
Thank you, Mr. Barrickman. Anyone who has known me during this campaign is aware that I have made myself available to them. I think it's important that you know who your candidates are going to be, and for that reason I have chosen to run a campaign where I got out to meet the people. If I haven't gotten to see you yet, I hope to in the next week and a half. I have found this to be a very interesting campaign, in that we have 3 candidates who are all qualified and who I believe will be ready to do the job the first day.
On behalf of the citizens of Barren and Metcalfe County, as well as the Plant Board and WCLU, we thank you, and I thank you for appearing here tonight. I think this has been an enlightening session. The public that's been watching this and hearing this is, I feel reasonably sure, has learned some things that most of the public didn't know, and I think that's good in selecting a candidate. I would urge everybody who has been listening to be sure to vote in this race on November the 2nd, and I would invite you to tune in again at 7 o'clock tomorrow night when we will have Judge Dickinson and Judge Redford here to answer questions and explain some more about the law to you, the audience. Again, thank you very much, and good night.
Our county attorney, Ben Rogers. 6 years working for you in the county attorney's office, which ranks in the top 20 in the state in child support collection. Ben Rogers, committed to prosecuting drunk drivers and working for business. Ben Rogers, on the job, working for you. Re-elect an experienced leader. Ben Rogers, a county attorney you can depend on.